of evidence that was presented yesterday, the first day of the public hearings. We will then once more remind participants in these public hearings about the rules of these proceedings. I need to emphasize the point that this is a legal process. It's a formal process of investigating a complaint that the information regulator is dealing with. So we will have to insist on keeping of the rules of proceedings. After the chairperson has reminded us regarding the rules, we will then hear evidence from Mr. Eugene Mteto. We will take a break, and after break, we'll then hear evidence from Dr. Graham Gilfillan. I don't know if he's here. I haven't. Comrade. Good. It's good to see you. And then we will hear evidence from the complainant, Mr. Clive Hardwick. We will take lunch. After lunch, we'll hear evidence from Advocate Nhlanhla Sibisi, who will be representing the respondent, which is RAV NPC. Then towards the end, we will sum it all up and close the public hearings for today. So allow me, Chair, if I may, to just give a quick recap of proceedings from yesterday. So the first witness that we had from yesterday was Mr. Sizeka Mabunda, who is a representative of the Department of Sports, Arts and Culture. In his testimony, he touched on the Copyright Amendment Bill and Performers Act, and the role that is played by his department in the music industry. What he emphasized in his evidence was the fact that the department is the custodian of the legislation that he was speaking to, that is now DTIC, but DSAC, which is the Department of Arts and Culture, Sports, Arts and Culture, also plays a role in terms of development of the Copyright Amendment Bill. There was reference that he made to the Berne Convention. And then lastly, he spoke about some of the common challenges that are experienced in the industry as a whole. Following that evidence, we heard from Mr. Gabriel Leroux, who is the Secretary General of the Trade Union of Musicians of South Africa, TUMSA. He gave a bit of a background as to the establishment of TUMSA, and then gave us a bit more details in terms of their work, reading out the 7 pillars. And then he took us through different types of royalties that are applicable in this line of work, but also spoke quite strongly about lack of regulations, particularly by some specific regulators. I think he mentioned ICASA in his evidence, but also spoke at length about the lack of transparency and accessibility to information by copyright owners. He touched briefly on the issue of administration fees or admin fees, which he said to be exorbitant, fees that are being charged by collecting societies. And there was a discussion around the issue of accreditation, whether or not there are benefits and what the challenges are of not being accredited as a collecting agency. Following that, we heard from Mr. Madoda Mxakwe, who is the Group Chief Executive Officer of the South African Broadcasting Corporation. In his evidence, he indicated some of the challenges that the SABC is facing in relation to individual artists, but also spoke about the obligation that the SABC has towards the industry. There was reference to the issue of double dipping or dual membership by artists, that is dual membership of various collecting societies. and then also spoke about the issue of distribution of various royalties. Lastly, we heard from Mr. Kadi Peche from CIPC, who spoke also on the issue of accreditation of collecting agencies and advantages for accreditation. We heard from him that there are 6 collecting agencies, 2 of which are accredited and 4 are not. He spoke about the mandate of the CIPC in terms of administering and managing sound recording rights. And then he touched on the issue of lack of recourse against non-accredited collecting societies. He gave an indication of what he thinks collecting society fees should look like. That was part of his evidence. But the point that he emphasized was the fact that copyright owners are entitled to access to information pertaining to content. The last point that he made was with regards to ambiguity in collecting regulations. Chairperson, those were the key aspects of evidence that we heard yesterday. At this point, I would like to hand over to you to remind participants about the rules. Thank you.
Is it on? Yes. Thank you very much, Mr. Dimba, Program Director, Mr. Dimba. Good morning, colleagues. Welcome to the second day of our hearing. I'll again read the rules of procedure for this hearing for the benefit of colleagues who were not here yesterday in the morning. And particularly you who were not here yesterday. So today I thought I'll read you the rules again. I think the team has given you a copy.
Yeah, I do have a copy.
Yes, yes, yes. So this is a complaint received by the Office of the Information Regulator with reference number CI 2421 between Hardwick Trading Pty Ltd, which is the complainant, and RISA Audiovisual Licensing NPC, known as REV, which is a private body. So I'll start with the authority of the chairperson. As I'm the chair of this hearing, the chairperson shall have the authority to require and administer oath or affirmation and rule upon procedural and admissibility of evidence issue. Recording, all testimony at the hearing must be recorded and may as necessary be transcribed. Administration of oath, all witnesses shall be sworn in before giving testimony. Cross-examination. The public hearing is set down for 2 days, and as a result, there is no right to cross-examine any witness before the public hearing. However, if there is any evidence which the witnesses dispute, such witness must submit a written statement, and such statement must be submitted to us as the information regulator. The evidence. During the investigation, the regulator may accept any evidence, including evidence that may otherwise be inadmissible in a court of law. See Section 81C of POPIA, which is the Protection of Personal Information Act. The relevance or materiality of such evidence shall be analyzed or evaluated and determined by the investigation team when compiling the investigation report. As we said, after this hearing, we'll look at all the written submissions and all the witnesses, the evidence given, then we'll give all the parties an investigation report. Where a person seeks to provide expert evidence during the investigation, his or her evidence must include a summary of relevant qualifications and experience, a summary of the expert opinion, as well as an explanation of the relevance of the expert's testimony or evidence to the matter under investigation. Legal representation. No legal representation shall be permitted to represent any person or witness. However, legal assistance may be allowed. This is not a court of law. It's a forum where we are dealing with a particular complaint. Then many issues out of public interest arises. The manner in which certain evidence may be received in camera. In exceptional circumstances and having taken into account the grounds for refusal of access to records contained in Chapter 4 of PAIA, which is the Promotion of Access to Information Act, the chairperson may make an order or ruling that certain aspect of such evidence be held in camera during or after the hearing. Offenses by witnesses. Any person summoned to attend and give evidence or to produce a book or document or object before the regulator without sufficient cause and fails to do the following: to attend at the time and place specified in the summon, to remain in attendance until the conclusion of the proceedings, until he or she is excused by the chairperson of the hearing from further attendance. Having attended, such person refuses to be sworn or to make an affirmation as a witness after he or she has been required to do so by the chairperson of the hearing, or after having been sworn or made an affirmation to answer fully or satisfactory any question of law put to him or her, or to produce any book, document, or object in his or her possession or custody or under his or her control, which he or he's been summoned to produce. Then these are the list of the offenses. Then such person will be guilty of an offense. Any person who, after having sworn or having made an affirmation, gives false evidence before the regulator on any matter, knowing that such evidence is false, or not knowing it to believing it to be true, is guilty of an offense also. Participation by interested person. Any person not invited to give evidence at this hearing may submit their evidence in writing to the investigating officers of the public hearing. And you'll see here there are two email addresses: dmoremong@inforegulator.org.za or svalemse@inforegulator.org.za. Please ensure that the following reference number is quoted in all correspondence relating to this matter, which is the complainant's reference number, which is reference number CI24 of 21. Miscellaneous: no person shall be allowed to answer or make any telephone call during the public hearing. Cell phone or mobile devices must always remain silent. Only invited persons shall be permitted to testify at the hearing, but the public have a right to be at the hearing unless ordered otherwise by the chairperson. The chairperson has the power to direct any person to be removed from the premises if that person is causing unnecessary disturbance or hindrance or obstructing or unlawfully influencing the regulator or any person acting on behalf or under the direction of the regulator in the performance of the regulator's duties and function under PAIA, which is the Promotion of Access to Information Act. The public hearing proceedings shall be recorded electronically, and all persons speaking at such public hearing shall speak closely to a microphone in such a manner as will ensure that the recording testimony or remarks will be accurate and trustworthy. At the commencement of the hearing, the chairperson may establish a time limit to be observed by all the speakers. Now, which is important, it's 11, the outcome of this hearing. The investigation report with preliminary findings and recommendation will be submitted to the Enforcement Committee, which is the committee, a statutory committee of the Information Regulator, which committee will make findings and make recommendations to the members of the regulator. The members of the Information Regulator, which is the regulator, Information Regulator, after having considered the recommendation by the Enforcement Committee, may serve the head of a private body with an enforcement notice in terms of Section 77, capital J of PAIA. That notice might confirm or amend or set aside the decision, which is the subject matter of the complaint, or might require that the said officer or head to take such action or to refrain from taking such action as the Information Regulator is specified in the notice. Consequences of non-compliance with such notice. The head of a private body who refuses to comply with the enforcement notice issued by the Information Regulator after the investigation of this complaint or any other complaint is guilty of an offense and is liable upon conviction to a fine or imprisonment for a period not exceeding 3 years, or to both such a fine and imprisonment. Closure of the hearing. The chairperson will close the hearing on the last day, but parties may still submit additional information or evidence relevant to the matter under investigation. This is issued by myself, Advocate Lebo Hagstrom. I'm the chairperson in my capacity as chairperson of the public hearing. Thank you. Mr. Dimba. Yes.
Thank you, Chairperson. May I just request, please, ladies and gentlemen, to minimize the use of electronic devices. They do tend to interfere with the signals for the broadcast. If you can, please do put them on silent mode. At this point, Chairperson, I'd like to hand over to the evidence leader.
Thank you very much, Program Director. Mr. Nemesis,
Thank you, Chair.
can we proceed and welcome the witness and
Yes.
swear them in?
Thank you, Chair. I'm going to open, before we call in the witness, which my colleague here will lead the evidence for the witness. I just wanted, Chair, through you, that I should open the proceeding today by reading an article. That was a 26 November 2021 article that was written by newspaper or online newspaper Ground Up. And the title of that article says, SA Music Industry Exposed, the money is not going to the artist. Chair, I'm not going to go the whole article, but I just want to highlight, without going into detail, the few statistics that that article has painted, which is exactly in line with what we are trying to establish in this investigation. The first statistics that has been published in that article, Chair, it refers to one of the collating society, which I'll not name it, but the article is available. That says that collating society is holding into more than 460 million undistributed revenue according to its latest financial statement. And these are royalties not paid over to record labels or to musicians. But in that article, I must say, the spokesperson of that collating society did object to that article, that reporting. But the journalist reported that they objected without explaining why in their balance sheet there's an excess of 463 million. The other collecting society, Chair, has been reported to be sitting on 60 million of license fees available for distribution, money that should be going to record labels and musicians according to its financials. And lastly, in that article, what has been reported is that South African Collection Society administrators charge some of the highest rates in the world. This was some of the evidence that was led yesterday, Chair. And for example, they said a 200 million collected by one of the collecting society in 2020, the agency spent 41 million on administration costs. And that collecting society has only 15 employees, but it charged about 41 million. This is some of the evidence that was led today, but when I go through and saw this article yesterday, I thought it's very important for this proceeding, and I thought I should open it with those. With those few words, Chair, I want to hand over to my colleague. She's going to lead the evidence. It's Ms. Zanele Zungu. She's the head of the Complaints and Investigation Unit on the information and the information regulator.
Yes, thank you very much, Mr. Nemesis. Ms. Zungu, you can proceed.
Thank you, Chairperson. Can the witness be sworn in?
Thank you very much. Morning, Chair. Morning, everyone who's here. Morning, Mr. Mtetwa.
Morning, sir.
Mr. Mtetwa, do you have any objection in taking an oath?
Not at all.
Do you consider the oath to be binding on your conscience?
Yes, sir.
If so, please raise your right hand and repeat after me. I swear that the evidence I'm going to give
I swear that the evidence I'm going to give
will be the whole truth and nothing but the truth.
will be the whole truth and nothing but the truth.
So help me God.
So help me God.
Witness sworn in, Chair.
Thank you. Welcome, Mr. Mtetwa. Ms.
Thank you,
Zungu,
Chair.
yes, you may proceed.
Thank you, Mr. Mtetwa, for honoring our invitation. I just want to start with the background of yourself. Can you just please tell us about the background of yourself in the music industry?
If you may allow me, that I do make remarks since I was not here yesterday before I gave the background. Thank you, Chair, for the opportunity and the foundation, Nelson Mandela Foundation. I must admit that it was disheartening for me watching this virtually. I was in court, and as I listened to the representative of the Department of Arts and Culture, which is the mother department that's supposed to represent us, I couldn't help it but to wonder, what was the department doing here? Because it did not answer to any questions. It displayed so much great lack of knowledge of the industry. the least that I had expected would have been its knowledge around the current amendment bill, the status, when you asked about the status, and he could not say certainly what was happening. But then it also gave me that assurance that no wonder we have artists dying poor under this leadership. It is not by default that these hearings are happening at Nelson Mandela Foundation. For today, for many of us as artists, it marks the victory that is certain and in our long walk to freedom. That you will begin today to deeply understand as I unpack the journey that we have traversed. In my head, I can hear Bongani Fasi praying as he posted a prayer in one of our WhatsApp group chat, the EFF Copyright Amendment Bill WhatsApp group. Bongani posted a prayer praying for me that I be guided by God to represent the inspirations and the hopes of many artists who are continuously dying poor, who would be watching today with much keen interest. So today I stand here before you, not on my behalf, but representing the aspirations and the hopes of many artists, actors, DJs, TV and radio presenters, emerging producers in film. So I would like to thank the information regulator for this opportunity and the Nelson Mandela Foundation for having taken our issues serious and tackling the bull by its horn. I am Eugene Mtetwa. I'm an artist. No, let me say, first and foremost, I'm a citizen of this country before I become an artist. I'm a composer, I'm a music producer, I'm a businessman in the industry, I'm a leader and a cultural activist. And unapologetically so. I've been in the industry for over 30 years. And been traveling. I traveled a lot with Lucky Dube, whom I was a keyboard player for. And my performance royalties from that era have not received a cent from that. I'm an artist with a group called Trompies. I've been earning around 300, 700 royalties for all the songs that you know made popular by Trompies. Sweetie Lavo, Mahasman, Foshos, Skiang Ngoma. But if I can show you my statements, I've never received anything over 5,000 rands for the past 30 years. I'm a member of Sambro. I'm not a member of Sampra. I'm not a member of Impra. I'm not a member of Capasso for reasons best known to me and that I will explain today. Because I have not found any truth in how all these collecting societies have been managed, in all what they say in defense of nothing, and in how they have become law unto themselves, regardless of the regulation that is there in terms of the needle time. And the leadership, mostly in all these, I was actually excited at the same time. I felt like it was a deja vu when I saw the names that are listed in this commission, or rather in this hearing. that would be appearing. And when I watched yesterday and I saw they speak with straight faces, under oath lying, all of them. So having said that, I think I've given enough background, but my experience is over 30 years. Thanks.
You have mentioned that you are a member of SAMRO, is that correct?
Yes, ma'am.
Can you hear me? I just want to find out, are you affiliated to any union in the music industry?
Well, when you speak of the union, it would be a labor movement, but this sector doesn't have a labor movement, except the one that I saw yesterday, which, again, I wondered whether this person was representing musicians, because all I heard was more of SAMRO as a board member, this, as a SAMRO doing this and this. And I found him very conflicted. But I'm not a member of any union. I used to be the acting secretary general of the Creative Workers Union, KUSA, which was an affiliate to COSATU.
What happened to that affiliation?
Well, unions in this sector don't survive because you would understand or you would appreciate the fact that artists are not earning salaries, monthly salaries, or an income, a stable income. Therefore, a union survives on subscriptions. But this sector cannot pay subscriptions because people are only seasonally employed. It is not a monthly income where the union can draw a subscription. Had we had leadership in government, that's where the department was supposed to come in and subsidize and help subsidize the existence of unions, a union. Also, the organizations that benefit from the sector have not been helpful, and maybe because the union represented largely black artists. And for them, artists mean nothing. So they wouldn't. I mean, for instance, RISA was supposed to be contributing towards the union. ECHO was supposed to be contributing towards the existence of the union because there is a revenue that they pay to the SITA. But that revenue ends up not being utilized because, in fact, it goes back to them, I don't know for whatever reason, but this is one sector that is not really unionized. So whoever says there is a union, it's not a union. It's a union by name.
What are the challenges that you
Ms. Zungu, I think we've got a problem with your mic. Can you assist her?
How do you put it?
Yeah, it's fine. What are the challenges that you have encountered as an artist in the collection of royalties within the music industry? You can just take us through.
I think the principle around collecting societies generally, it is to collect on behalf of its members. And I would base this to the current two collecting societies that are regulated because the others are law unto themselves. SAMPRA and IMPRA, one of the requirements for accreditation is that you must provide a list of your members. And when you apply and provide a list of members, what is not said and told to the regulator that we do collect on behalf of members and non-members. We collect on blanket licenses, but we only distribute to our members. And that is one reason you have a surplus that is forever declared by these collecting societies. And not being a member of IMPRA and SAMPRA, it means that I have no access to any information. Now, you get accredited based on your distribution plan, the approved distribution plan, which requires that a collecting society must provide information in terms of the royalties it is paying you. Where, what, which song was played where, and how much it accrued. But in the past years of both the existence of these two collecting societies, I have received 900 rands, 1,000 rand from SAMPRA with no statements. I have written to SAMPRA to say I need to know what are these royalties for, because I keep on seeing money coming into my account. I couldn't get the statements until I wrote to the regulator, and the regulator, instead of holding them accountable, he seemed to be a very good friend to them. And he said, look, I will get you the statements. It's not the duty of the regulator to get me the statements. And I found him very conflicted and very lenient towards SAMPRA. Whilst on the other hand, he was taking IMPRA to court, or rather under scrutiny, he did not take SAMPRA under scrutiny. And I couldn't get any help, to such an extent that I ended up writing to the regulator. I wrote to the DG, Lionel. I wrote to the Minister of Trade and Industry. To date, I have not received any fulfilling responses from all these authorities. Now, the challenges, the serious challenges are that when they collect as they collect on a blanket license, they have failed to account. You can't even hold them accountable. I have tried by any means necessary to hold all the collecting societies, including Sambro. You've seen me staging a sit-in at Sambro, chaining myself at Sambro, out of frustration. I have written to IMPRA requesting information. I couldn't get information. I get paid by SAMPRA, I get paid by IMPRA. I'm not a member of both, and I think that is transgression to their accreditation, because that's what they promised to the regulator, that they will collect on behalf of their members and distribute efficiently. The process of distribution is you distribute to the last cent if you're a collecting society, and only retain not more than 20% of your admin costs. But I'm sure you heard even yesterday, there's a copyright review report which was adopted by the Parliament, confirming that Sambro, for instance, has been taking over 30-something%. Yesterday I was shocked that you were saying it's going up to 40%, whilst artists and composers are dying poor. The beneficiaries of these collecting societies or these collected royalties, I will say it, I'm one person who subscribes to a statement that was made by Amika Cabral, who says, hide nothing to the masses, tell no lies, claim no easy victories. I will not shy away from mentioning names of people, mentioning names of the organizations, because we are here to fix. And that is my thinking, that you are here because you want to hear the truth so that you can be able to fix the issues. Now, when you look at Sambro, you have publishers who dominate, and I'm sure you heard that from Gabi Leroux saying that those who have more power to say things are the publishers who represent a number of artists under their wing. Whether truly or not, we cannot tell that, because they hold this proxy right that is lifetime. You can't have an audited list of those people that they represent. And by virtue of representing 20,000 members, it means in the AGM or any decision-making process or meeting, they have the upper hand. When they say the ship goes left, the ship will go left. They pose as those processes, they pose them as if they are a democratic process, but in truthfulness, they aren't. We are dominated by the publishing companies, and those publishing companies are not the publishing companies from the emerging and the previously disadvantaged artists. They are foreign-owned, first and foremost, dominating and lying in their information. So the most important thing is this information that we are seeking even today. It is the forever missing information, and they mislead people by saying things. I watched a workshop just recently that was run by SAMPRA. SAMPRA collects on behalf of performers and producers. Now, when you look at the term producer, first and foremost, in the amendments that are currently happening, we are being failed as artists. Because the term producer means it's very ambiguous, and you would know in law that when you start using the words that are ambiguous, you are set to fail. It is not by default that these companies, all these companies in the music industry, are run by lawyers. The CEOs are made lawyers. I mean, the lawyers are made CEOs in this company. It is not by default. So that they can study the law and see the cracks and be able to manipulate the system. Producer is, you have somebody who produces the sound, is a producer of that sound, creatively so. You have a producer who sits in the studio and guides the process of the recording of that music. He's a producer. And then you have record companies who are executive producer by virtue of investment. We keep on talking about rights. I've argued even at international platforms to say we cannot talk rights when rights are trampled down by privileges. We must talk privileges. You can't say the one who commissions it owns it and ignore the one who creates it intellectually, thus it is called intellectual property. But we have that dominance of record companies who then take ownership of our music. You have people who have signed deeds of assignment. I'm one of those who once signed deeds of assignment to Gallo Music Record Company. That says, at that time you were forced to sign your rights to the company. They would not release your album without you giving them the rights to your music. And that is perpetual. There is no way you will be able to get those rights back, because part of that deed of assignment states that you will only be able to reclaim your music 50 years after you're dead. An insult to us. How can a dead person claim? These are some of the challenges that I've raised with all these collecting societies, because again, the law talks about owners. They all call themselves owners. There must be a distinction between the owner and the holder. They are not owners, they are holders. And if they are holders, I should be able to say to the holder, I'm not satisfied with how you manage my works. But unfortunately, that is not the situation.
Okay. So on the issue of royalties, I just want to find out from you, because I heard you mentioning that you have never received more than 5,000 rand. So how are these payments made? Are they made monthly, quarterly, or yearly?
Well, with other collecting societies, it's quarterly. With record companies is after 6 months. And the way these are distributed, you will never get a statement that shows you that these are the total sales. For instance, from a record company, these are the total sales. And this is how much, based on your, the percentage that you've agreed upon on your contract. But because we are focusing on collecting societies, let me say, there is a quarterly payment of royalties. One, for instance, with Sambro, you will have what they call royalties. It will be a royalty run for that particular quarter, followed by what they call a non-royalty distribution. So there's one royalty distribution which can be scientifically proven that you are paid based on a number of works that you have under your profile. But the non-royalty distribution is a distribution that says these are unclaimed, supposedly unclaimed royalties, which is lies. These are the royalties that belong to people who died and never left any information around their next of kin. These are the royalties that would have been robbed from the real owners. I've discovered a very divisive way that they do this, where you find that administratively, Sambro would say, join as a member, we will administer, monitor, and distribute royalties according to the profile you have. But there's a new system that they have devised of now saying, if your song becomes popular, it then gets removed from documented works into undocumented works. So if this is the general practice. If I am about to release a song or an album, I would submit to Sambro as a member that these are the works that I'm going to be releasing, here are the composers, and here's the split. But I have found out that later on, for instance, a song like Makhasman is now appearing 11 times or 29 times on the system of Sambro with different work numbers, meaning Neskasi, it would be a car that was stolen, and iphinda-phindiwe 29 times, so it has different engine numbers and different piece numbers 29 times. Now, if I have to earn royalties from that, if you are a broadcaster and you're playing Mahasman, which Mahasman would you say you are playing out of the 29 Mahasman that are appearing in the system? How much will you allocate to all the 29 Mahasman if it is the same song and some have got different composers, some composers who have risen from death, and came and claimed that they were composers on these songs. And this is in the system that we never had access to, because remember previously we used to fill up a paper, it was a paper trail, it was a paper submission to say our notification. It is only in 2020 that I got to realize that most of the songs that are popular, on all the songs that are popular from Trompies, they are on undocumented works. So what it means is that we are not earning royalties from those that are undocumented. It means now they don't know who the composers are, or the possibilities that there is a dispute, that somebody came and said, this song, I was part of it 19 years later. I forgot to notify 19 years ago that I was part of this song. So those are some of the royalties that we haven't. Now, the challenge with that is that when you then get this access that we are talking about now, access to this information, it was only 2020 when we accessed the portal, and I realized that most of the songs, one of the songs that I had, Metro FM sports program, Madlu Put, was playing that song every day, 5 times or 6 times in his program for 2 years, never earned a cent. It was on undocumented all this time. I didn't have access to that information. Only in 2020 when I have access, and I say, wait a bit, guys, how did my music move from documented works that I had notified into undocumented works? Because now they don't pay, when it is in undocumented works, they don't pay the royalties. The royalties sit in a suspense account, and then after 3 years, that money is then taken back into distribution, what you are asking. I'm talking about the non-royalty. This is the money then that is taken back into distribution, into be redistributed. But the distribution process of that, it says, if I end 10% of the entire budget or entire amount that was collected for that particular royalty run, and I earned 10% of that. Now, on the non-royalty distribution, I will get proportional to that 10%. The money that doesn't belong to me. And who gets more? It is publishers. That is why, because they remember that they collect on behalf of 10,000 people, so they would have collected, for instance, let me simplify it and say, if I am a publisher and I earn 10 million, this particular royalty run, which can be scientifically, calculated or mathematically calculated. On the non-royalty distribution, I will get proportional to the 10 million. But whose money is it? Who do I distribute it to? It because it says it. It's non-royalty distribution. So there's a possibility of me saying, oh, but this is the money that I can use for anything that I can do as I wish, because no one can come as a member and claim that from that 10 million that you got on a non-royalty distribution, I deserve 5,000 rands or 10,000 rands. So it's a divisive way. And then when you then get this revelation of this is how messy the very same service that they promised for me to be their member, will administer. And you find that there's maladministration, that gross maladministration. And then you claim and say, look, 1994, I released Kyangengoma. It became a household name. It became a national anthem. It got high rotation in 1994, 95. If I claim today, they would say, oh, by the way, we have a prescription policy. You cannot claim beyond 3 years or 5 years. Whose fault is it? Is it my fault that my music moved from ghostly moved from my documented works into undocumented works? Did I have access to your system? No. Now, if you're saying I should claim, it's 2022, you're saying I can only claim 3 years backwards. Skangongoma was on high rotation 94, Mahasman in 1998. Was Skangongoma played in 2017? No. So what do I claim? 0.
Okay. Mr. Mtaswa, just on the issue of a prescription, can you maybe perhaps tell us when does prescription start to run according to your understanding? Because you mentioned the issue of 3 and also 5 years. So I just want to understand from the music industry, when does it start to run?
Well, my understanding of prescription in the first place, it deals with debts. It has to deal with ikolot. My royalties at Sambro, Impra, Sampra, Capasso are not debts. That's an investment that I have made over years working and creating music. So if one has to apply, for argument's sake, has to apply what they call prescription, it is 3 years backwards, generally. But what has to be satisfied before you start saying, I am therefore applying this prescription, you should have notified me of the situation. Now, without access to this information, I wouldn't have known that these songs have been there on undocumented works for 22 years. And then when I say, no, I need us to go back as far as when I notify these works, and then you say, no, prescription doesn't allow us. You are saying to me, let bygones be bygones. Whatever wealth that I should have accumulated over 28 years, I must let go. Yet the very same money that you were collecting created a job for you, even benefits. Now, prescription only applies when one is informed about the situation, and if I don't act, then you can begin counting 3 years.
So does it also apply to undocumented works?
Well, in the first place, yes, they do apply it arbitrarily. They do apply it, which is not supposed to be the case. Yet, I'll make an example of Sambro, for instance. There's a precedent. When those were coming from exile, coming back to the country, they were given their royalties that were dated back to 20 years before they arrived. Yet today, I must face this policy that says, your pension fund, and I'm not scared to say, as I said, I don't hide anything. My pension fund over 30 years is around 300 and something thousand. If I retire this year, I would get not less. I would get around 300 and something thousand. But somebody who started working at Samro 10 years ago will be getting more than I get because of this prescription of these undocumented works that have robbed me not only the royalties, but also my pension fund, because what they would then do is, if I earn 15,000 rands royalties, this side, they will contribute proportional to my retirement. So if I get 300 rands as royalties, they are going to contribute 300, proportional to 300 rands into my retirement. So not only that artists have been robbed their royalties, but also their retirement funds.
How does one then become aware of these undocumented works?
By default, if you are smart like Eugene, and you are able to access, to use a computer, then you'll be able. I shudder what's going to happen to those who are in rural areas. You asked yesterday, the department couldn't explain what it's doing, or it has to do, or it had done for those who are in rural areas. So this information is also biased, only for those who are smart like Eugene.
Noted. You also mentioned that you also receive some funds from a collecting society, however, you're not a member of that. Were you a member before of that collecting society?
This collecting society, I'm sure that you are referring to, it is IMPRA, which belongs to the organization called ECHO, which I was the founding chairperson of that organization. This collecting society has been law unto itself, mismanaging royalties, but it is a collecting society from independent record companies, meaning that it is proudly South African. Now, what I then decided to do, because the first distribution of the royalties on needle time, it's based on needle time. I saw a PR exercise that I objected. I even called the Minister of Arts and Culture to say, it is unfortunately that you posed with IMPRA to say IMPRA is distributing royalties. Prior to that, I'm sure others would remember when I knelt down before Hlaudi and saying, please Hlaudi, SABC, don't pay the royalties before the two collecting societies have come into an agreement of the royalty rate and collectively saying, yes, we agree. And what happened then, SABC decided to pay. After paying, then they did an exercise, a PR exercise, where they paid people selectively, the AKAs. They chose people that they wanted to utilize in order to do this PR exercise. And one of them was Chico, who has publicly come out that he got 2 million that he did not deserve. Now, you have a regulator sitting there and watching all this, but not acting. So what I decided to do, I said, let me join and be, because the regulator, when I was writing to the regulator and saying, there's something so wrong that is happening around this needle time distribution. He said, why don't you join them and be a member? And this was referring to SAMPRA, and I felt that if the regulator suggests that I join an organization to be a member, what is he saying? Is he promoting anti-competitive behavior? To say, I must now not have any choice of joining my any other, or even establishing my own collecting society. So I joined IMPRA deliberately to say, let me see if I join, will I get this information? And indeed, I got the information when I joined. So it means those who are not members of these collecting societies have no access to this information. And they will not get their royalties. So when I joined, I got the information and I got paid. But I got paid peanuts because when I asked, where is Lucky Dube's performance monies, royalties? And the answer I got was, oh no, that one is a very complicated process. I said, no, but Needle Time was established for backing singers, for performers to benefit from this. But now if you're only distributing to the principal artist or featuring artist, what about the backing artists, the session musicians? No, it's a complicated one. So no, we can't talk that. We'll talk about that later. That was the only reason I joined, but then I resigned because I felt this was not worth it.
So what? So when you are not a member of that particular collecting society, you are not able to access the information that you're referring to.
No, you can't. I've got an email where the regulator is saying that I must join SAMPRA in order to access this information. And only one statement I got when, with the help of the regulator, I got a statement from SAMPRA that says, Mahasman, 300 rands. Sweetie Lavo, 300. There, no information that says, Mahasman, Radio 2000, 10 times, SAPC. And the regulation does state that you should be able to give such information. It shouldn't be like, somebody sat in his bedroom or her bedroom and typed, okay, how many songs? They have 11 songs, Mahasman, Sweetie Love. How much do you allocate? Oh, allocate 500 for that one, allocate 600. This is the thuggery that is experienced in the industry.
I've also noted that. So are you able to calculate or maybe estimate is how much is due to you in terms of royalties?
No, I don't. One, the collecting societies are pointing the finger at SABC or broadcasters that they don't get reports, efficient reports from the broadcasters. The broadcasters are saying, no, we've paid. When they've paid in terms of blanket license, I don't know how do you pay on a blanket license and then, but expect that that whatever percentage should then be allocated to how many times. It is no longer on how many times my song was played. It cannot be. Logic must apply. It cannot be. If I am collecting on behalf of the industry, I'm the only collecting society, and I get 10% of the revenue at SAPC. How do you then go back and say, out of this 10% that we got, your songs, they occupy 9% of the 10%. There's no such. You're collecting on behalf of the entire industry, but you're only distributing to your members. If you have 5 members, you will only distribute to 5 members. And I think that's where the problem is, because you have SABC that has a system, very expensive system, that has never been utilized. You have Sambro that has a very expensive system that has never been utilized. In this digital day, you have people who are saying, we don't know how many times your songs was played because we have a problem. SABC did not give us the clear list of how many songs, but yet when you pay royalties and provide me with a statement, you say my song was played 10 times, so it's lies.
But are you able to then maybe go to SABC and request that they give you a breakdown statement as an individual person?
I did a sit-in during the time of Peter Matlare when he was the group CEO, alone in his office. That was the only time I got a statement of what SABC had paid, 750 million rands to one of the collecting societies. But when I looked at that statement, it did not have how many times which songs were played, because that was dependent on the radio DJ or the presenter noting down the songs that they would have played on that particular day. So if that presenter writes, instead of Mahasmani, writes Makasmani, it's a mistake, it's an error, it's a human error. It then gets reported under the collecting society as Makasmani, yet it is Mahasmani. Now you ask yourself again, there's RISA. What are the ISRC codes for? Because these are the codes that should help you to say, if I've written Makasman, the ISRC code must say it is Mahasman, not Makasman. So it is deliberately done so that there is this looting. The songs are placed on the side as one, unidentifiable, royalties unclaimed royalties. So it's impossible to do that, yeah.
Okay. So when you sign up with these collection societies, are you made aware prior as to how much admin collection fee are they going to charge an individual, or is it only something which comes after?
When SAMRO was established in 1967, in the apartheid era, it was a private company. So as I say that it is law unto itself, that is why when you have a copyright review report that says they are taking a commission of more than 30%, you have not seen any report or any entity that sees to it that SAMRO deals with the issue, because there was a recommendation that it needs to deal with the issue and lower its cost to lesser than 20%. But who has the responsibility of monitoring and enforcing that SAMRO should retain not more than 20%? No one. The regulator himself says, there's nothing I can do with SAMRO, Capaso, because I'm not regulating. Yet SAMRO and Capaso, as you correctly asked, they are registered under CIPC. So the Companies Act should be applicable. Corporate governance should be there. This is one thing that is lacking in this industry. Corporate governance, as Advocate Tulima Donsela once said, it is something that is not in existence. And that is the problem that we have. We have the same